Hello everybody, welcome to ixamBee. This is Amrita, law faculty, and I'm going to discuss with you all some important questions from Sebi Grade A Legal Officer Examination 2022 point of view. Before I start with the discussion relating to the important questions, I would like to remind you that do subscribe to our YouTube channel of ixamBee and stay updated with videos relating to questions and also other content that we deliver on YouTube, which is very beneficial for you for exam point of view. And also you can go and visit our website, that is www.ixambee.com, for course details and whatever courses are available at ixamBee. For government exam preparation, you can be updated by any of these methods. You can contact us, you can call on this number, and also you can write at hello@ixambee.com. आज के इस वीडियो में जो डिस्कशन मैं करने वाली हूँ दैट इज़ गोइंग टू बी कम्प्लीटली फॉर सेबी ग्रेड ए लीगल ऑफिसर एग्जामिनेशन एंड आई एम गोइंग टू कवर 100 इम्पॉर्टेंट क्वेश्चंस. दिस इज गोइंग टू बी द पार्ट 1 फॉर दिस वीडियो और ये सेबी के एग्जामिनेशन पॉइंट ऑफ व्यू से बहुत ज़्यादा इंपॉर्टेंट है. देर आर सम 2-3 पॉइंट्स. फर्स्टली दिस इज गोइंग टू हेल्प यू अंडरस्टैंड द इम्पॉर्टेंट एरियाज दैट कैन बी देयर फॉर फ्रॉम एग्जाम पॉइंट ऑफ व्यू. At this point of time आपका एग्जाम है 20th of Feb को and you don't have much time left, so this will help you in understanding the key areas where you have to focus. This will also help you understand what kind of questions can be framed, which kind of questions can be framed. ये 100 questions देखने का फ़ायदा आपको होगा कि आपको questions का pattern समझ में आएगा, किस किस तरीके के questions आ सकते हैं. And lastly, from revision point of view, this is a very good exercise. That's why I have started with it. ये वीडियो का part 1 है. Stay tuned for to ixamBee for more videos relating to this part. Starting with the very first question. A law made by Parliament having extra-territorial operation shall. A law made by the Parliament having extra-territorial operation shall be deemed invalid, be deemed ultra-vires, be deemed unconstitutional, not be deemed invalid, not be deemed invalid, or ultra-vires. You can see the options are very near, but the question is from a very basic area, that is from a law that is made by Parliament, which is relating to the extra-territorial operation of the laws that are made by Parliament. Very initial part of Constitution has been picked over here, and the answer is D, that it will not be deemed invalid. Article 245 also makes it clear that the extent of laws that are made by Parliament and by the legislature of the states shall be, of course, subjected to the provisions of this Constitution only. Parliament can make laws for whole or any part of the territory of India, and legislature of the state similarly can make laws. No law can be made by Parliament that is even made for some extra-territorial operation that shall be deemed to be valid. That means no law that is made by Parliament which is relating to extra-territorial operation, due to that it shall not be deemed to be invalid. It should be still treated as valid only. You can see the question is twisted in the sense that how it is a very easy question, but it has become twisted as they have used the many times what happens, we skip the negative words. जैसे हम लोग पढ़ते वक्त ये no को अगर skip कर ले तो हमारा ये sentence का meaning change हो जाता है. So like this you have to be very keen while you are answering questions and also while you are studying for the exam. Second question है, which of the following is a legislative power of the president? Precedence is another important topic from constitutional law, and out of all of these 5 options, which of the following is a legislative power of the president? All of these are actually powers of the president, but what they have asked here is relating to the legislative power of the president. The legislative power of the president has been asked here, and the answer is of course power to promulgate ordinance only. Other powers are not legislative powers, and Article 123 of the Indian Constitution directly provides for this power. Question number 3. Which of the following statement is correct? A preamble is a part of the Constitution and can be amended under Article 368. Preamble is not a part of the Constitution and it cannot be amended. Preamble is not a part of the Constitution but it can be amended under Article 368. Preamble is a part of the Constitution, can be amended only if no change is made in the basic structure, and preamble can be amended by Parliament simply by an objective resolution. Preamble is another important topic from constitutional law. Now this is relating to the amendment of preamble. What is the law on this particular point? If you are clear with it, you can answer this question very easily. Answer is D. Preamble is part of the Constitution and it can be amended only if no change is made in the basic structure of the Constitution. ये एक necessary condition है कि there should not be made any basic structure should not be changed in the Constitution. Only then it can be amended. And this has been clarified by Supreme Court that preamble is a part of the Constitution and can be subjected to constitutional amendments as under 368. And it is heart and soul of the Constitution and so on. You can go into the details. Preamble is an important topic from constitutional law. So do revise cases and topics relating to questions relating to this topic. Next question है concept of directive principles of state policy. ये भी question पूछा जा सकता है not only for directive principles but और भी कई features है constitution के जो borrow किए गए हैं. So you should remember which provision, which portion has been taken up from where, what is the source. Now directive principles of state policy is borrowed from Ireland. This table I have shared with you, you can go through it. It is typically covering all the features that have been borrowed from various sources. So this can be very helpful for you. ये video stop करके भी आप इसको देख सकते हो, or else the better solution can be इस video के description में PPT attached है. So this PPT you can take help of and go through this question because this is also very important one. And it can be a good revision for you over here from exam point of view, that what all features have been borrowed from which source. Next question. Reasonable restrictions on freedom to assemble can be imposed. This is from freedom to assemble, and that can be imposed when? Reasonable restrictions can be imposed when it is in the interest of sovereignty and integrity of India or public order. It is in the interest of sovereignty and integrity of India only. It is in the interest of general public and for public order. In the interest of general public, unity, sovereignty and integrity of India. In the interest of sovereignty and integrity of India or public order and morality. यहाँ पे आप देख रहे हो options काफ़ी near है, कुछ minor changes है, but the options are very near, so you have to be very keen while you are solving such kind of questions. The answer is A. Clear it is. Reasonable restrictions can be imposed on freedom to assemble, freedom to assembly, when it is there imposed in the interest of sovereignty and integrity of India or public order. This is clear from Article 19 itself. As Clause 1 talks about all the freedoms, Clause B talks about to assemble peaceably and without arms, and correspondingly the reasonable restriction for Clause B, Subclause B is covered under Subclause 3, that is talking about reasonable restrictions relating to freedom of assembly particularly. For all the clauses, the different subclauses have been provided. Like for subclause A, it is covered under subclause 2. And you can see for subclause B, that is in subclause 3, you can see what grounds are there. And this question has been picked directly from these grounds only. Next question. If the directive principles of state policy is infringed, then there is a remedy in court, there is no remedy by judicial proceedings, there is remedy in the parliament, there is remedy in court of a special magistrate, none of the above. When a directive principle of state policy is infringed, then what remedy can be there? What is the answer to this question? The answer is B. There is no remedy by judicial proceedings. Here you have to choose the most appropriate answer actually. And directive principles infringe होने के बाद कोर्ट में आप उसको चैलेंज नहीं कर सकते. Like for fundamental rights, you can directly go and file a petition before High Court and Supreme Court. You can go and seek writs, but for Directive Principles Part 4 it is not so. There is no remedy by judicial proceedings. This option is the most appropriate out of all the options. कई बार कुछ क्वेश्चंस में आपको द मोस्ट अप्रोप्रिएट ऑप्शन चूज करना होता है, एंड दिस इज वन एग्जांपल ऑफ दैट. Nature of directive principles of state policy is entirely explained under Article 37 of the Constitution. Welfare state theory के अंदर ये concept work करता है, and Article 37 talks about its enforceability. Next question. Any charge for impeachment of the president may be preferred. Now this is again from the topic of precedent. If you are preferring any charge for impeachment of the president, then that can be preferred only in one house of people, only in council of states, only in the joint session of the parliament, or by either house of the parliament, or by the Supreme Court. So if you are very clear with Article 61 of the Constitution, that is dealing with impeachment of the president, you can easily answer this question. That is D. By either house of the parliament can frame a charge for impeachment of president. 61 of the Constitution directly provides for the procedure of impeachment of president, and president के topic में से ये भी एक important article है. So go through the procedure, and what is the voting related procedure, that also you have to be very thoroughly prepared with. And that charge is preferred by either house of the parliament, and wherever it is preferred, then the other house, corresponding house where it was not preferred, shall investigate the charge or the cause, and after that investigation, then president shall be given a right to appear, and so on. When the resolution is passed, then the president shall stand impeached. Question number 8. The total number of ministers, including the prime minister, in the council of ministers shall not exceed 10% of the total number of members of the House of People, exceed 15% of the total number of members of the House of People, exceed 10% of total number of members of Parliament, exceed 15% of the total number of members of the Parliament, exceed 15% of the total number of members of the Council of States. So ये सारे options में से आपको correct option choose करना है, and this is also a very direct question. The provision is there that total number of ministers, including prime minister, in the council of ministers shall not exceed 15% of the total number of members of the House of People. This has been directly picked from Article 75 of the Constitution. ये भी आप पढ़ लेना कि ये provision है provided under Article 75 Clause 1A. Which article of the Constitution provides for the appointment of Comptroller and Auditor General? This is direct article based question, but ये एक important authority है exam point of view से, तो यहाँ पे आपको article numbers भी पता होनी चाहिए, and the article that is the correct one is Article 148. It directly provides for the appointment of CAG, that is Comptroller and Auditor General of India. Article 148 भी mark कर लीजिए, important है. Next question. Supreme Courts and the High Courts are to be the courts of record. This is mentioned under which articles? This is also an article based question, but from the very important articles of Constitution, and the answer is also very direct. The answer remains B, that is 129 and 215 respectively. 129 declares Supreme Court as the court of record, and 215 declares High Court as the court of record. This also gives them the power to punish for their own contempt. This also question, if asked anytime, you should remember that this article covers it. 129 for Supreme Court, 215 for High Court. Now next question. Now we are starting with administrative law related some questions. This was up till Constitution. We picked some questions from Constitution which were important. Now from administrative law, law principle de legalite. What this means? This has been directly picked. This is a principle. What this actually means? It is relating to administrative law, and the answer remains A, rule of law. Very important topic from administrative law. is actually the meaning of this phrase, that is la principle de legalite. Expression rule of law has been derived from this French phrase actually, and it is implied by states in the administration of justice. No doubt rule of law is the very concrete base of administrative law. The doctrine of rule of law, very important, expounded by Professor A.V. Dicey. He developed it actually, and Sir Edward Coke expounded it for the first time. Question number 12. Supremacy of law is the first meaning of rule of law. This was established by whom? That supremacy of law is the first meaning of rule of law. Of course, Professor Dicey, because the three rules relating to rule of law, the three explanations have been propounded by Professor A.V. Dicey, so there is no chance of confusion here. Supremacy of law is the first meaning of rule of law, and that has been established by Professor Dicey. Question number 13. These are the three principles of Professor Dicey relating to the principles of rule of law. First, supremacy of law. Second, equality before law. And third, predominance of legal spirit. This is the order. You should remember the order also if any time you are asked the first, second and the third meaning of rule of law. Question number 13. Delegatus non potus delegare. Now, this is also a very prominent and very discussed maxim, I would say, from this subject, and it is an easy question. Delegatus non potus delegare means what? This is relating to delegated legislation. It says that the delegate cannot further delegate, but the options seem to be very similar, so it's necessary that you read the question very properly and very keenly. That is very important, and don't make silly mistakes in such kind of questions. Delegatus non potus delegare is a principle in constitutional and administrative, both these subjects cover this, that no delegated powers can be further delegated. Next question, rule against bias. This is a question that has been picked from principles of natural justice. That rule against bias is which principle of natural justice? Audio altrum partem, nemo judex in sua causa, nemo debet esse judex in propria causa, B and C, A, B and C all. So this principle, that is rule against bias. Rule against bias is which principle? You should also know the alternative names, okay? Alternative names. Knowing alternative names of all the principles is very important. You never know which name is asked when. And if you know these names, then solving these questions is very easy. And the answer here is D, that is B as well as C. Both mean the same thing, and rule against bias also talks about this principle of natural justice only. That is, no man can be a judge in his own cause, and rule against bias or bias of interest actually describes that particular maxim only, and is another word that is used for that maxim only. No man shall be a judge in his own cause, which is known by both the ways, nemo judex in causa sua or nemo debet esse judex in propria causa. Both mean the same thing, and this is talking about the basic principle of rule against bias or bias of interest. Audio altrum partem, or the rule of fair hearing, is the next principle of natural justice, that both the sides shall be heard. Coming to the 15th question. Third aspect of the principle of natural justice is, we are aware of the two principles of natural justice. Which is the third principle of natural justice, which is a comparatively recent development? And that also, if asked, you should know. All these four statements have been given, and these are the options, out of which you have to choose the correct one. The third aspect of the principle of natural justice is what? Speaking order, reasoned decisions, audio altrum partem, rule for reason. You can carefully observe, इस तरीके के भी questions कभी कभी पूछे जाते हैं कि आपको statements दिए जाते हैं, and उन statement के अलग अलग combinations बना के आपको options दिए जाते हैं, and you have to choose the correct options from this particular question. So it is very, many times the question is very easy, but आपको choose करते वक्त गलती नहीं करनी है, because यहाँ पे statements अलग से दिए होते हैं. So be very careful when you are solving such kind of questions, and don't make silly mistakes over here. And the answer here is going to be speaking order plus reasoned decisions, which is the third aspect of principles of natural justice. Audio alterum partem and rule for audio alterum partem is the second principle, and rule against bias is the first. But we are going to talk about the third aspect of principles of natural justice, and the answer is going to be A, that is covering statement 1 as well as statement 2, that is speaking order and reasoned decisions. Rule for reason ऐसा तो कोई principle है ही नहीं. We have rule against bias, which is also not the third aspect of principle of natural justice. Coming to the you can go into details about this particular recent development, speaking orders or recent decisions, that this is a new developing third principle of natural justice, कि सारे जो decisions होते हैं, orders होते हैं judges के, they must be accompanied by reasons, so that there is less arbitrariness, less scope of arbitrariness is there. 16th question, which of the following is included as an exception in the command theory of John Austin? अब हम jurisprudence पे आ चुके हैं. Jurisprudence से एक very important theory है, that is John Austin की, उसमें से command theory pick की गई है, and the question is relating to that which of the following is not an exception. It is included as an exception under the command theory of John Austin, and the answer is E, because all of these options, if you go into details of command theory of Austin, all of these options are actually directly covered as exceptions under the command theory of Austin. Austin says that every law is a command, and all of these kinds of laws, declaratory or explanatory laws, repealing laws, imperfect obligations related laws, those laws which are not having any sanction behind them, those kind of laws, all these laws are covered as an exception to the command theory of John Austin. Now the next question, question number 17. Pound, Eyring, Eldridge have adopted that school or method for the study of legal philosophy. According to these jurists, the essential characteristic of law is that it shall prevail and it shall actually represent the common interactions of man in their daily life. यहाँ पे जो theory discuss की गई है उसके कुछ points भी दिए describe करने के लिए, and आपको hint के तौर पे philosophers के नाम भी दिए हैं. तो jurisprudence जब आप पढ़ोगे, do remember that which philosopher belongs to which school of thought to answer such kind of direct questions very easily. अब ये जो क्वेश्चन है और ये जो फिलोसोफर्स हैं, ये कौन से स्कूल को बिलोंग करते हैं, दैट यू हैव टू आंसर, एंड द आंसर इज सी, दैट दे बिलोंग टू सोशियोलॉजिकल स्कूल ऑफ जूरिस्प्रूडेंस. अब यहाँ पे आप सोचोगे कि सोशल इंजीनियरिंग थ्योरी का मेंशन नहीं है, एंड बट यू शुड ऑलवेज नो दैट इट इज नॉट नेसेसरी कि वहाँ पे हमेशा सोशल इंजीनियरिंग थ्योरी का ही मेंशन होगा, बिकॉज वो सिर्फ प्रास्को पाउंड ने दी थी. आयरिंग एंड एल्ड्रिच वर हैव आल्सो कंट्रीब्यूटेड इन देयर ओन वेज टू दिस particular school of thought, and you have to understand and always remember that आपको पता हो कि कौन से philosophers कौन से school के हैं. at least jurisprudence के point of view से आपको पता होना चाहिए. Sociological school of jurisprudence is no doubt a very important school. According to which rule of interpretation, the question that has been placed now is going to be from interpretation. According to which rule of interpretation, the meaning of words should be known from its accompanying or associating words. ये भी एक interpretation तो no doubt is an important topic for Sebi examination. उसमें भी ये एक direct principle उठाया गया है, and कौन सा rule है, कौन सा principle है interpretation का, जो कहता है that the accompanying or the associating words should contribute to the meaning of a word. And the question is very direct again, nociter associis. This principle directly means that it literally means that it is known by its associates, and whatever words are there, they should be given a meaning in the light of the words that are accompanying or associating its words. जो इंसान की कंपनी होती है वैसा ही वो बन जाता है. ये सिंपल चीज अगर आप याद रखोगे for this particular principle, that is more than enough for you and to remember this particular maxim. Heydon's rule, this is also another important concept. Heydon's rule is another name of which rule of interpretation? This also you can answer within 5 seconds I would say. Mischief rule, of course Heydon's case से ही develop हुआ था mischief rule of interpretation. You have to be very clear with the rules of interpretation. The most important and expected topics from interpretation of statutes is this only. बाद में आप ये वीडियो को पॉज करके या फिर पीपीटी भी देख सकते हो. हेडन्स केस के कुछ इंपॉर्टेंट पॉइंट्स मैंने यहाँ पे लिस्ट डाउन किए हैं कि व्हाट आर द बेसिक प्रिंसिपल्स, कि मिसचीफ को किस तरीके से सॉल्व करता है मिसचीफ रूल, जो लॉ का पर्पस डिस्कस करता है, एंड पहले कॉमन लॉ क्या था, देन व्हाट वाज द मिसचीफ दैट वाज टू बी ट्रीटेड बाय दिस which the common law did not provide earlier, and what is the reason of that particular remedy that is provided by that law. This was discussed in the Heydon's case and it was gradually developed as a result of Heydon's rule. Also it is known as Heydon's rule or mischief rule. The last question for our discussion in this video, and next video I will be covering another set of 20 questions. Be tuned for this entire series of 100 questions that we are covering from exam point of view for Sebi Grade A Legal Officer Examination. Which of the following is an example of beneficial construction or legislation? Beneficial construction या beneficial legislation कई तरीके के होते हैं, and out of these options which you can see here, Workmen Compensation Act, IPC, Indian Partnership Act, tort law, constitutional law, what do you think which is an example of beneficial construction or legislation? This is a very easy question, just common logic you have to apply. Labor laws are all based upon this kind of legislation, interpretation, beneficial construction I would say, and Workmen's Compensation Act is an example of that. Beneficial constructions involve giving wide meanings to the statutes, as much wide as you can, and under the welfare state theory, labor laws have been developed and they protect and give relief and benefit to the beneficiaries under that particular legislation. Another example from labor law only I can give you, like Maternity Benefit Act. This is also a beneficial legislation for that particular class of people, including the women who require maternity relief. So for their welfare, beneficial legislations or beneficial constructions work. We have Sebi Grade A Legal Stream online course available at ixamBee, and you can take benefit of this course. These are the important features which you can see, the key highlights of this course. And ixamBee पे सारे mock tests भी फ्री में अवेलेबल है, आप कभी भी जाके सारे mock tests अटेम्प्ट कर सकते हैं. www.ixambee.com. memory based question paper भी अवेलेबल है, and what not is available at ixamBee. And also we have expert faculty for legal that is here to help you and guide you anytime. आप आपके queries comment section में भी लिख सकते हो इस वीडियो के, and stay tuned to ixamBee for such kind of videos and updates relating to government exams preparation. Don't forget to subscribe to our YouTube channel as we make government exams preparation easy over here. Thank you everybody. Thank you so much.